This case is really interesting. This is Tito. This is out of the Ninth Circuit. I believe this is a federal court in Washington state. Trump had put a freeze on allowing in people purporting to be seeking asylum. That was one of the open door policies that the Biden administration had put in place. Oh, they're just asylum seekers. They're just looking for a better life. But of course, they have all these NGOs telling these people how to fill in the blanks on the forms, how to fabricate an asylum claim. They're not actually asylum seekers. They're just economic third world migrants. They want the free stuff America gives out to everybody. Of all of these migrants who come the free healthcare, the free education, the free housing, the free cell phone, everything. Free spending money. It's absolutely crazy. And so Trump put a freeze. He says, listen, we got to check this process. If someone's genuinely an asylum seeker, meets the actual requirements, well, then we'll let them in. But we're putting a freeze, pencils down. We're not just going to pretend we know that there's a lot of fraud going on here. If you're ever compelled to use force in defense of yourself or your family, the good news is that if you defended lawfully, you can be very hard to convict. But did you defend lawfully? Because if you don't know where the actual legal boundaries for self-defense are, it's the easiest thing in the world to innocently step over them, and now you're extremely easy to convict. Good news. In just a single day, you can become an expert on the law of self-defense and make yourself extremely hard to convict. On Saturday, April 26th, I'm holding one of my only twice-a-year full-day law of self-defense advanced classes. This class is taught live by me and live streamed to you. It teaches you everything you need to know in one day, and there's plenty of opportunity for personal Q&A with me as well. Even more good news, when you register today, you save yourself 50% off the standard registration, but that discount ends soon. Your 50% discount and many more details on this advanced class are available just by pointing your browser to lawofselfdefense.com/advanced today. And I'll also drop that link in the description. I look forward to seeing all of you there. So this is one of the cases where the unelected black robe tyrannical federal district trial court judge. But Judge Chuang had said, Doge isn't allowed to do anything. You can't let them touch anything. And then Trump had taken what was really outrageous about this. First of all, just that injunction is outrageous. This is the executive branch. It's not the judicial branch. Why does Judge Chuang get to tell President Trump how to execute his executive branch authorities? But then Trump took one of these guys and had been on the Doge team and hired him into the federal government, into the executive branch. So he's no longer on Doge, and basically put him in charge of processing a lot of these payments. Some of these payments were to organizations overseas that provide medicine for HIV, important stuff. But just to make sure they weren't going to violate this injunction that Doge can't do anything, they sent this judge a letter, a request for clarification. They said, listen, you've enjoined everyone involved with Doge, but this guy no longer works for Doge. He's now in charge of giving people in the third world HIV medications. And we'd like to start doing that so they don't die. But we want to make sure if we allow him to do that, that your injunction doesn't cover him anymore because he's not part of Doge anymore. And the judge wrote back and said, no, it still covers him. Anyone who's ever been part of Doge can do nothing within the executive branch of government, even if it means getting people their HIV medications. That's how outrageous this judge is, Chuang. I'm going to talk in a minute about how conflicted he is too. Impeachment articles against this judge have been filed. We'll talk about that as well. But then just yesterday, we got this from the United States Court of Appeals for the Fourth Circuit. Here we go. The defendant's motion for an administrative stay, that would be the White House motion, asking for a stay or freezing of Judge Chuang's injunction against the president, against Doge. They granted that stay. Now, they only granted it for a few days until March 27th, which is tomorrow. But that was just for them to have some time to write up their memorandum of law, their explanation for why they're granting the stay. So that's a win for Trump. Then we had this case. This case is really interesting. This is Tito. This is out of the Ninth Circuit. I believe this is a federal court in Washington state. Trump had put a freeze on allowing in people purporting to be seeking asylum. That was one of the open door policies that the Biden administration had put in place. Oh, they're just asylum seekers. They're just looking for a better life. But of course, they have all these NGOs telling these people how to fill in the blanks on the forms, how to fabricate an asylum claim. They're not actually asylum seekers. They're just economic third world migrants. They want the free stuff America gives out to everybody. Of all of these migrants who come the free healthcare, the free education, the free housing, the free cell phone, everything. Free spending money. It's absolutely crazy. And so Trump put a freeze. He says, listen, we got to check this process. If someone's genuinely an asylum seeker, meets the actual requirements, well, then we'll let them in. But we're putting a freeze, pencils down. We're not just going to pretend we know that there's a lot of fraud going on here. And so this judge put an injunction on that, said, no, you have to let everybody in. Anyone who says the word asylum, you have to allow them into the United States. They could be a terrorist. It could be, who knows? Doesn't matter. If they say the word asylum, you have to let them in. And the White House asked for a stay on that. And the judge just wouldn't respond. He wouldn't answer. He wouldn't say whether he was going to stay his injunction or not. Now, of course, we know the real answer is he wouldn't, but he doesn't want to put it in writing. And it got so bad that the White House actually wrote to his parents, the Court of Appeals, and said, Your Honors, your son, this judge, is being outrageous. Will you please order him to put down the video game controller and do his job and rule one way or another on this issue? And that's what the Court of Appeals had to do. They sent the judge this letter. This court is informed, meaning the Court of Appeals is informed that the government's motion to stay the preliminary injunction remains undecided. That was from March 3rd. They're writing this letter to the judge. His parents, the Court of Appeals, are writing this letter to the judge March 19th. Okay? So 16 days later, it's been 2.5 weeks. The government's motion to stay the preliminary injunction filed with the trial court, on March 3rd remains undecided. The trial court is respectfully requested to rule on the damn motion by no later than 12 p.m. Friday, March 21st. We're giving you 2 more days. Trial judge, Judge Whitehead. I mean, I've never seen anything like it. It's absolutely amazing. It's like the adults have to step in and corral these runaway federal trial court judges. And then the Court of Appeals of the Ninth Circuit, in fact, stayed the injunction. Now, they didn't stay it entirely. They said, listen, whoever was approved for asylum prior to Trump's executive order on January 20th, those are still valid asylum seekers. But anyone after, and we're talking potentially millions of third world migrants would be coming in, anyone after is excluded. Trump's pause on new asylum seekers is in place. So the inflow of new people has ended. So another win for President Trump. Now, something I want to mention that's a little bit awkward, because I've been one of the loud voices criticizing the Supreme Court for not being more aggressive about stepping in and checking these renegade, unelected, black robe, tyrannical federal trial court judges. Chief Justice John Roberts. Like, come on, you're supposed to be the patriarch of all these. Get your kids in check. Instead, he issues a mean memo to Trump about impeaching these judges, and we're going to cover some of these impeachments. They're in the pipeline. But the truth is, the pragmatic reality is that when the Court of Appeals are in fact staying these trial court injunctions, those are wins for Trump, of course. They're also wins for Chief Justice Roberts. This is what Roberts wants. He wants these cases to be resolved in the normal course of the litigation. There's a TRO, it lasts for 2 weeks, gets turned into a preliminary injunction that can be appealed to the Court of Appeals, and the Court of Appeals makes their ruling. And then if somebody wants, they can appeal to the Supreme Court. So when these stays are actually taking place, wins for Trump. Also, it makes Chief Justice Roberts look like he made the right call, that this is the way things are going to be properly resolved. And it's still only been a couple months, folks. It's March 26th, January 20th, Trump was sworn in. So it's been 9 weeks. I'm not happy about the delays, this lawfare, but if we can cover it in 9, 10, 12 weeks and not have to totally disrupt the constitutional order, I think that's the path John Roberts would like. And I don't think the rest of us who would like to see more rigorous action, like see the federal trial courts stripped of the authority to issue injunctions to the Article 2 executive branch. Any one of 733 federal judges can freeze the Article 2 executive branch of government. It's outrageous. But doing that is something not the kind of thing you would see from Chief Justice John Roberts. All right, so we have those stays. That's good. Now, how about the impeachments? Let's talk about impeachment because 3 more recently came down the pipeline. We have impeachment articles against Judge James Boasberg. He's the judge presiding over the Alien Enemies Act case right now with the Tren de Aragua terrorists that Trump is trying to summarily deport from the nation. He's put a freeze on that. A nationwide class. He's made TDA a nationwide class, none of whom can be deported from the United States under Trump's Alien Enemies Act proclamation. I've covered that at length. Congressman Brandon Gill has issued impeachment papers against Judge Boasberg. Then we have what happened. Congressman Andrew Clyde has issued impeachment papers against Judge McConnell. Judge McConnell is in Rhode Island. He's a federal, unelected, black-robed, tyrannical federal trial court judge who put a freeze on, these were money cases. These were NGOs whose money flow was stopped by Trump. He's saying, no, you can't stop the money. This guy is wildly conflicted on these cases, as is Boasberg. And we have Representative, is it Ogles? Ogles. Here we go. Andy Ogles issued impeachment articles against Judge Chuang, which we just were reading about. Judge Chuang with the Doge injunction that just got stayed by the Fourth Circuit. Let's take a look at some of these actual articles of impeachment and talk about how these judges are also otherwise conflicted because they really, really are. All right, so here's the articles of impeachment against Judge Boasberg. So I'm not going to read the whole thing. I just want to go to where we have the grounds for impeachment. Separation of powers. That's the grounds for impeachment here. The Constitution grants the president broad authority over the executive branch, including national security to protect the nation, including the Alien Enemies Act. Remember, Boasberg is the guy putting the freeze on the Alien Enemies Act. As Supreme Court has explained, for a court to second guess a president's determination under the Alien Enemies Act would be assuming the functions of the political agencies of the government. It's not for the courts to question the president's determinations under the Alien Enemies Act because these are matters of political judgment for which judges have neither technical competence nor official responsibility. That's Ludecky v. Watkins. We've covered that case in earlier shows. The post-World War II case where Truman was summarily deporting a German national under the Alien Enemies Act, and the Supreme Court said that's fine. But despite that, Judge Boasberg has done exactly what the Supreme Court command not be done, illegitimately substituting his own judgment for that of the elected president, usurping the role of the executive, unilaterally taking upon himself the power and authority of the president. So he's abused the powers of his judicial authority to prioritize political gain over the duty of impartiality, prevented Trump from removing aliens, ordered to turn planes around midair of aliens that were already removed from the U.S., jeopardizes the safety of the nation, abuse of judicial power, detrimental to the orderly function of the judiciary, attempted to seize power from the executive branch, overstep his judicial authority, created a constitutional crisis, therefore guilty of high crimes and misdemeanors and should be removed from office. Well, there's other reasons why Boasberg should be removed from office. So Judge Boasberg, it turns out, has an adult daughter, Catherine Boasberg, who works for an organization called Partners for Justice. This is one of the money laundering NGO organizations that gets its funding from USAID. So its funding is being cut off by Trump's policies. Guess what the mission of Partners for Justice is? It's to oppose mass deportations. Exactly the issue that Judge Boasberg is ruling on in these Alien Enemies Act cases. So he has an adult family member, an adult child, whose income personally and the income of the organization she works for, which collects many millions of dollars in this USAID NGO money laundering, parasitic relationship upon the American taxpayer. And he's making rulings in these cases. He's clearly conflicted. The Code of Conduct for United States judges says, and I'm going to quote here, a judge shall disqualify himself, recuse himself in a proceeding where the judge's impartiality might be reasonably questioned, including but not limited to instances in which the judge or the judge's spouse or a person related to either of them is known by the judge to have an interest that could be substantially affected by the outcome of the proceedings. That should be in the articles of impeachment too, folks. I don't know why it's not. Let's talk about the Judge Chuang impeachment. Now, this is from Congressman Ogles. Chuang is the Doge judge. Said not only can no one from Doge have anything to do with anything in government, even if they're no longer with Doge and they've been hired by the federal government as an employee, they still can't do anything. So let's take a look at what these articles of impeachment look like. Again, I won't read the whole thing. I just want to get to the actual cause of action. So Judge Chuang issued a preliminary injunction ordering the government to reinstate access to email payments, security notifications to all the fired USAID employees. So Trump had fired a whole bunch of USAID people under Doge's recommendation, and because they're closing down USAID. And this judge said, you got to hire all those people back and you got to give them access to all the governmental systems, all the executive branch governmental systems. Again, this is effectively a compelled delegation of executive authority from President Trump, to whom the Constitution under Article 2 gives the entirety of executive authority under the federal government. This Judge Chuang is saying, no, I have the authority to delegate executive branch power that's superior to the elected presidents. That's what he's effectively doing here. Judge Chuang has, without merit, marginalized the president's Article 2 authority, which vests power to conduct foreign policy in a president of the United States. Patent violation of the separation of powers prevents the president from responding to threats, especially since these USAID people know they're all going to be fired, right? You think they might do anything when they have access to the systems again? That might be bad for America. Judge Chuang, in mandating immediate provision of access to government systems without regard for the president's duty under Article 2 to defend the national security, has done so in a manner that is arbitrary and capricious. We know that USAID, this is under other administrations, by the way, did not consistently ensure that awards provided for in various projects were done properly, was found to have financed hundreds of thousands of meals for Al-Qaeda fighters. Judge Chuang failed to consider his decisions could easily inflict irreparable harm on Americans and American interest, engaged in conduct so lacking in due concern for the separation of powers and national security of the United States. He is guilty of high crimes and misdemeanors and should be impeached. It turns out Judge Chuang is conflicted. For many years, more than a decade, he's been on the board of a left-wing NGO organization to bring migrants into the country. In 1 year, it got millions of dollars, and it's been in operation for more than 25 years. So certainly tens or hundreds of millions of dollars of NGO funding has gone through this organization. Not only is the judge on the board, and that might be an unpaid position for the judge, the law might require that, but guess who else is involved as an officer in these NGOs? This judge's wife, and she can be paid. She could well be paid more than the federal government is paying Judge Chuang. So he has a personal financial interest in these NGOs, this money laundering, and their political goals. He's absolutely conflicted, financially conflicted in this case. He should properly be recusing himself, which would be the honorable thing to do, but he's not. He's issuing orders when he's conflicted. Clearly, an appearance of impropriety that the Code of Conduct for United States judges says requires his removal from this kind of case. That should be in the articles of impeachment as well. What about the third articles of impeachment set forth against Judge McConnell? This is the Rhode Island judge who put an injunction against Trump, who was freezing money flows to various NGOs in that part of the country. Let's take a look. Now, finally, we have articles of impeachment that are talking about conflict. The Code of Conduct, United States judges. A judge should refrain from political activity. Also, there should not be even the appearance of impropriety. This judge has served on the board of the Rhode Island branch of Planned Parenthood, contributed hundreds of thousands of dollars in political donations to Democrats, Frankly, it looks like he bought his federal seat on the bench. He's allowed his personal political opinions to influence his decisions. He made a public comment just a couple years ago. We fall back on this kind of stereotypical that judges should have no opinions and whatnot. That's just not true. Well, you're allowed to have opinions. You just can't let them interfere with your duty of impartiality on the bench. Different sentencing, he advocates for different defendants, depending on whether they're women or black or transgender. You know, Lady Justice has a sword in one hand and a scale in the other and a blindfold, because this is absolutely not what a judge is supposed to be doing. When you're sentencing someone, you have to take a moment and realize this, you're a middle-class, white male, privileged person, jeepers, needs to understand the human being who comes before us may be a woman or maybe black or maybe transgender or maybe poor. Why does it matter if they've committed a crime they're being sentenced for? We formed a committee to look at race in our court. So racial preferences, hiring in the court system. Thanks, Judge. More DEI, more anti-white racism. There's something sick and broken. Conflicts of interest. This is what I wanted to get to. In this case, state of New York versus Donald Trump. It's not just the state of New York, of course, it's a bunch of states. He serves on the board, Judge McConnell, of the nonprofit organization Crossroads, Rhode Island. Previously served as the chairman of the board. Now he's the chair emeritus. And again, this might be an unpaid position for him, but clearly he has a personal interest in this organization and its political goals. And the federal government, in 1 year alone, gave this organization $20 million. And they've been operating for many years. This year, so far, it's only March, had already gotten $3 million in funds from the government. And they are a named plaintiff in the lawsuit against Trump. A clear conflict of interest. Code of conduct. A judge must avoid all impropriety or the appearance of impropriety. Absolutely conflicted. So finally, they're starting to incorporate these conflicts into the articles of impeachment, guilty of high crimes and misdemeanors, and should be removed from office. Folks, I've mentioned before, I'm not an investigative journalist. I'm not a private detective. I'm not going to go investigate all these judges in detail. But I swear to the Lord, every time I look at one of these judges, they have clear conflicts of interest. It is just absolutely reprehensible.